Sorry for the delay, everybody. We were just sorting out some technical issues. Seems like we've got a small crowd today, but nevertheless, still the same vigor and enthusiasm to help you guys out. Feel free to leave some comments or questions you have in the chat, but how about we get started? So today we're going to be talking about articles and related issues to articles. Now, we often talk about articles, but the proper terminology is practical vocational training. It's throughout the act, they always talk about PVT, practical vocational training. And it's just something that's evolved. And actually, it's a bit of a convention that we refer to it as articles. So when it comes to articles, you've actually got two options. You've got 12 months and 24 months. With 12-month articles, you would be required to undergo a rather lengthy course that you complete within an aggregate of 6 months. We'll actually dive into the legislation specifics in a bit. But typically, the 12-month route is seen as the quicker path. It does, however, limit your learning opportunities because you've only got 12 months, and typically, principals only seem to expose you to more interesting and more in-depth matters after 12 months, after you've learned, picked up the necessary skills, candidating, to be able to run a file. And also limited exposure, unfortunately, goes hand in hand because you're still relatively new. There's this sometimes unfair presumption that you might not know what is necessary in order to run a particular matter, etc., etc., and hence you are rather confined to a particular area of law. 24 months, truth be told, I feel that articles should be a little bit longer, but anyway. Because it's 24 months, for the first year, typically, you are taught how to go about legal matters, what's good etiquette, how you go about engaging clients, giving clients advice, the structures, the systems, etc. And because of this, you're actually given the opportunity to experience different things. For instance, you'd be consulting with counsel independently of your principal, or you would actually be arguing matters. In some practices, they send the candidate on day one to start their matters and run the matters from day one. However, in most firms, there is a bit of an orientation phase. Again, 24 months does give you greater exposure, in my opinion. Most employers prefer people who are looking for contract articles for 24 months because employers typically have this view that for the first year you're teaching candidates, so you're not actually making money from the candidate's efforts. In the second year, it offsets the costs involved in training candidates. So 24 months is in an employer's mind is a little bit more commercially viable. So let's dive into the 12-month article option. Now, this is predominantly regulated by the regulations. If you look at Regulation 61B, it'll actually tell you what is required. It speaks about an uninterrupted period of 12 months that you have to serve articles for. And also, you need to have completed your 400 notational hours before you enter into the 12 months contract. So that's a bit of a problem for some people because some people come out fresh out of university and they want to do the 12-month option, but they haven't done the law school option as we call it. Unfortunately, the Act only speaks of prior to commencing articles. That being said, there is a bit of a workaround and you'll see it in a bit. So now we've got the 24-month contract for articles, which is the stock standard and everybody is used to it. Now, what's important is it speaks of that you must also do a course program being 150 notational hours. Now, that's the compulsory course that's actually offered by LEAD. Unfortunately, it is an absolute requirement for a 24-month contract. You do have to do it. And also, they mention an important caveat that if you do not if you fail to complete the program, within a period of 36 months, you'll lose all that progress you made. So it's a use it or lose it approach to it. So bear that in mind when you are undergoing your articles, that you must complete your exams and the course as soon as possible. You can't delay it inevitably. You can't delay it indefinitely, sorry. Now, here's the but. You can register for a 24-month contract, and then during the 24-month contract, you can do law school for 400 notational hours. So you can shorten it to 12 months. Bear in mind, you must do law school outside of normal working hours. There they specifically say outside of normal working hours. But this is at least a way to shorten one's articles, and it also allows you the opportunity of flexibility. So that's what articles are. Now, vacation work. I'm a very strong proponent of vacation work. You should, if you can, try to do it. It's great. It shows enthusiasm for the legal field, as well as it shows your potential principals that you are acquainted with certain concepts, certain customs, and unfortunately, the legal field is rather rich in customs and conventions. So the vacation work definitely gives you an idea of what's out there, what it looks like, how it works. In my opinion, actually, when we do hiring, we actually look to see who's done vacation work. Unless we want to train the person up from the ground ourselves, we look to see who's done vacation work, where they've done it. It's definitely a strong factor. It gives you a bit of a preference among your cohorts. So I definitely recommend it. Now, improving prospects of securing articles. I'm going to say it, I've said it again, and I'll say it again. When you're preparing your CV, please, guys, look at your grammar, focus on that. Now you've got tools such as Grammarly, which dramatically improves your use of the English language. Also, the presentation of your CV, truth be told, if it's sorry, just give me a moment. Sorry about that, ladies and gentlemen. My apologies about that. Unfortunately, the law does not wait for anybody. So I was on CVs. You definitely want a CV that, while not ostentatious, it does come across as professional, communicates what needs to be communicated in any good CV, and in particular, uses easy to read fonts. I'm going to be particularly egregious about the font usage these days. Please avoid Times New Roman. It's not the easiest on the eye. If you have to use a particular font, perhaps use Calibra or Arial. Definitely Arial, since it's the de facto default font for purposes of court processes. And again, an easy to read CV is preferred over that which is, for lack of a better expression, overcrowded with information. Nicely spaced CV comes across as easy to read, it flows. So that's definitely something you want to tackle with your CV. In particular, by doing these things, you're also selling yourself as a prospective candidate attorney. And that, in my opinion, is rather important. You definitely want to use this as a tool to sell yourself. As odd as that sounds, but in essence, any sort of meeting or employment opportunity is where you are selling yourself. So now interviews, definitely you want to be on time. Punctuality is by far the most important. Also, it's indicative of how you would appear in courts. If you appear half an hour late for an interview, your prospective principal might view you as being likely to be half an hour late for the likes of a court appearance. And yes, there is some correlation between the two. Now, I'm a big fan of Dress for Success, coming across as appearing very presentable, looking professional. This also helps from a psychological perspective for yourself. You're dressing successfully, you feel sharp, you feel like you're in the zone, so to speak. This is a great way to go about doing things. Please do not come to an interview, for instance, with flip-flops, shorts. I would not recommend it unless the interviewer is saying that you should do so. Again, when I used to do job interviews, I would dress how I would normally dress on a day-to-day basis, so they can see me as I would be on any given day in the office. Something I'd recommend is that you research the firm that you'd like to perform your articles at. Having an idea of the firm, the area of law, it just gives a better idea of the value you could actually offer to the firm. And yes, again, we're speaking about selling. This is the value proposition that you're proposing to the firm. Hi, I'm interested in property law. I've always wanted to do X, Y, and Z. In fact, I'm still doing this because I'm so interested in this. It shows that you're adding value, that you are a good fit for the firm and the direction in which the firm is going. Definitely something I'd recommend. Now, personal traits. Now, the reason why I'm mentioning that on this particular slide, especially in the context of securing articles, is yes, we notice the spelling mistakes. Yes, my pet peeve is the space before the semicolon in everybody's CVs. I do not know why it's there, but that's my pet peeve. Indicating that you are results driven in your CV and in your interview will definitely allow you to grasp articles a lot easier. Law firms are very results orientated. Their clients, yes, clients come to us for services, but clients at the end of the day want a particular outcome. So as long as we're results orientated, you are more likely to be employed as a candidate attorney. And most importantly, a desire to learn and grow. Yes, sometimes you might have to take the initiative to learn and grow, but that's how law works. Law is something that you must engage with on a rather regular basis to learn and feel it. I often say that law has a particular feel to it. And once you get a sense of what it feels like, your judgment as to how a particular case is likely to go improves. And also, when I say grow, it also means getting out of your comfort zone, doing other aspects of law that you would not otherwise have wanted to do. I think back onto my years when I was in university, I actually wanted to do criminal law. However, I started my articles in the commercial and corporate law department. That was very interesting work. I did do criminal law. I've done almost all types of law. And because I had great exposure, I realized that criminal law, while interesting, was not per se my forte. I was a little bit more interested in things that were a little bit more challenging. So always remember that you want to learn, you want to grow. A lawyer that doesn't learn every day is a very poor lawyer and likely to get sued pretty soon. So vetting a potential principal. Now, I mention this because without saying too much, there have been lawyers who claim to be legal practitioners, well, persons who claim to be legal practitioners, but are not, and they've even taken on candidate attorneys. So, first port of call, see if the person that you would like to be your principal is a legal practitioner. The moment he's not, red flag, immediate red flag, because with the rates of crime, it's likely that you are the subject of the scam. Think cheap labor who has a qualification. It's a lot more prevalent than I'd like to admit. Also, something that I'd recommend is that you take steps just to ascertain whether or not there are a maximum of 2 candidates already employed by the same principal. The absolute maximum is 3 candidate attorneys, obviously 2 plus yourself. So that's definitely something you want to ascertain upfront or as soon as possible so that you are not in contravention of the law. It will become a complete mess when when you're about to be admitted and you discover that, oh no, your principal had 5 candidate attorneys and you were the 5th. That would invalidate your articles and then you would have to start from scratch. Also, something else, the reputation of the firm. Sometimes firms have certain reputations. For instance, firm X, they are rather harsh. Firm Y, they are not as bloodthirsty in the approach to legal matters as other firms. Again, you're trying to find a firm that fits and in which you can integrate and you're compatible with. Also, this helps you with securing articles. Again, you know the reputation of the firm. You did an SCA matter just 2 years ago. That was actually a very interesting matter. It comes across that you are very interested in the firm. Then next thing, reputation of the principal. Certain people have paraded as, well, conveyed themselves to be legal practitioners when they weren't. There have been people who are admitted attorneys, not on the practicing role, but purport to be on the practicing role. And of course, that is a problem for purposes of articles. So you definitely want to look after yourself as well. No point in serving years with a particular principal and you discover the particular principal could not have been your principal. And lastly, field of law. Again, you might have an interest in a particular field. You might want more experience in a particular field. This way you can narrow it in. And also with medium to large firms, they typically have certain principals who are in a certain department. So this way you can ascertain with almost laser guided precision which field of law you want to land in. And then contract of articles, the actual document. This is a strange one, but some candidate attorneys have confused their contract of the articles with an employment agreement. No, they are the two wildly different agreements. In fact, I postulate that it's possible to article without being employed by the firm. It is, well, receiving remuneration in any case. It is a bit of a interpretation of the law, but nevertheless, it's two different agreements. The contract of articles regulates the relationship as candidate attorney and principal, where obviously the employment agreement is employer versus employee. The two are markedly different, and they're interpreted, handled, and dealt with very different from each other. Now, also, the contract of articles is literally a prescribed contract. You can literally download a copy from the LPC's website. They do not like it when you deviate from that document. I tried. They were not too pleased, and they proceeded to accept their version. Anyway, now, of course, they're going to require you to provide certain documents, for instance, character references, certified copy of your ID, degree, or academic record, etc. Again, this can be found out on the LPC's website. Fortunately, the website actually has quite a bit of information. It's very informative. They have quite a lot more information than we are actually mentioning today. And it's basically a question of following the procedure and completing the correct documents and forms. Now, diving into registration, the form can actually be, as mentioned, can be downloaded from the website. There are certain requirements. For instance, your original contract with articles plus certified copies needs to be provided to the LPC, certified copy for ID, degree. You're going to have to pay a registration fee. You'll need 2 character references. They can literally be letters. Some people have done affidavits. That's not exactly required, but I would say it's permissible. And a request by your principal for your rights of appearance in the district courts and other forums. Now, this is a letter. This would take be the form of a letter by your principal, which your principal signs, and which you send to the LPC. What I'd recommend is you actually draft it. It need not actually be lengthy, 10-pager. No, my request for rights of appearance was literally a single sheet of paper, and that was perfect. Then there's the registration form. If you've got criminal convictions, it's time to provide this information to the LPC, let them know what's going on and what happened, what has been done, how you've been rehabilitated. Again, disclosure here is your friend. Do not hide this from the LPC. If they find out, they will oppose your admission, and the court will even remark that you're unfit. You're not a fit and proper individual to be admitted as an attorney. Also, something to disclose other proceedings against yourself, for instance, liquidation proceedings, court matters, disciplinary hearings, and the like need to be disclosed. Again, non-disclosure typically is met with severe consequences, such as your application being dismissed. So, rights of appearance. Again, it is signed by your principal. Now, bear in mind, you receive rights of appearance in the magistrates courts, in the district courts. In fact, I think it's actually limited to no high courts or SCA or the CC or regional courts. There is a little bit of back and forth as to whether or not a candidate attorney can appear at the CCMA. I suppose our courts will clarify that in due course, though. But for the first year, your rights of appearance are limited. This is for the public's protection, as well as to ensure that the degree of your mistakes is not as great as it otherwise could be. So after a year of having rights of appearance, well, after a year of your contract of articles being registered, you can ask for regional rights of appearance. Again, it's a letter that you send off to the LPC, signed by your principal, and you get your certificate. That will entitle you to appear in the regional magistrates courts, not the high courts or the Supreme Court of Appeal or Constitutional Court. So now there's also been questions about the extension of rights of appearance. Under the Attorneys Act, it was possible. Under the LPC, have not seen it happen since. Unfortunately, I am rather doubtful that you can get extension these days. It's not provided for in the legislation that I've seen. And I think in particular, the intention was to stamp out the abuse of candidate attorneys by requiring them to remain candidate attorneys. Also, no candidate attorney can appear in a high court or courts having a similar status. For instance, the Equality Court or the Land Claims Court. That unfortunately is a big no-no. Please do not. The magistrates courts and the high courts can and will report you for appearing without the rights of appearance, as it's unprofessional conduct. Myths of articles. We've already dealt with the extension of rights of appearance. And also acting as a candidate attorney after the end of your articles. Unfortunately, when the 24 or 12 months, as the case may be, once that lapses, you're no longer a candidate attorney. You can no longer appear in the courts or forums. You need to be admitted. You cannot continue to act or purport to act as a candidate attorney. You can't even say you're a candidate attorney, unfortunately. So bear that in mind. Also, in articles, typically articles are rather fast-paced. The workload is rather heavy. The salary is not as much as one would like. But then again, it is viewed as an apprenticeship. So there are various views on that. I'm always in favor of anything below minimum wage is not acceptable. But that's just my personal view. Again, this is very controversial. So bear in mind that articles can be intense. It is, if you suffer at least one mental breakdown during articles, that's par for the course. So be prepared. And I wish I was joking about that. So I have not seen any questions regarding articles, and that's all the slides that I've got. So if you have any questions, feel free to unmute yourselves or put it in the chat. It's always at this time that everybody gets shy and
Hi, everyone.
Hey, and I see that your RAM problem has been resolved.
Yeah, I'll find out in 2 hours. Yeah, I've
Fair
got the
enough.
tail end of the discussion, but I had gone through the slides earlier, and it's quite well structured, so I can't really disagree with anything that Bruce has said thus far. I can, however, offer a tidbit which will go a long way to assisting you. If you're in an interview, consider asking your interviewer who you will be registered under and to who you will be reporting. These are usually two different attorneys. More often than not, you may be registered under a principal, but you will be working the majority of the time under an associate or a professional assistant. For many other reasons, mostly because you'll be cheap labor and easy to abuse. Calling a spade, it is what it is. If you ask during your interview under who you will be working, you'll more likely than not be told to which department you'll be allocated. Or it'll be, if it's a one-man show, it's quite easy to see under who you'll be working. If there's one attorney, that's who you'll be working under. But then there's also most likely a hierarchy of secretarial staff who will make your life easy or horrible. Most likely horrible, but be that as it may. If you are lucky enough to get a good firm who treats you well during articles, do not be naive in thinking that you should stay there beyond articles. You will always be a candidate attorney. In 80% of law firms and many of the associates with whom I converse, this is a true fact, as you are always seen as the person who was recruited fresh out of university. A lot of firms do allow the graduation in standing and in reputation, but these are also few and far between. As Bruce said, a mental breakdown during articles is par for the course. At least one, yeah, that's lowballing it. But it will test you mentally, it will test you physically, it will test every part of you, and you will hate it at times and wonder why the hell you did it. Finish up, keep to it. It's worthwhile getting admitted at the end of the day. Otherwise, you would have wasted 4 years of your life. I see we have something in the chat.
Yes, if one has a civil case, it is required to disclose it on the LPC form for CA. Yes. If judgment has been obtained against you, you do need to disclose it. This actually speaks to whether or not you're a fit and proper person and you comply with the law, as attorneys are required to at all times abide and comply with the law. So bear that in mind. But again, disclosure here at this point is your friend. If you hide things, I wish you good luck, and that will be a very newsworthy admission application, as no doubt some of you have seen.
I see we have another comment from Bridget. Bridget, this is something which has been dealt with in the slides, and by no means your fault, make no mistake. A lot of law firms are just not looking for articles. Other times, it's also a thing of how one's conducted the search. For example, if you've just sent out emails, a lot of law firms actually want the physical CV in front of them instead of having to print it out. Sending an email is very impersonal. And while it does have a far-reaching effect, for example, you can apply for articles in Cape Town if you're in Johannesburg. There's still something to be said about receiving a physical CV if you know a law firm is looking for a candidate attorney. Also, go through your CV, make sure it's not too long. Make sure that little certificates of award that were received in grade 1 or grade 2 aren't in there. It takes up unnecessary space and disclosure space. And something that I've found works well, it just specifically speaking to that you've not been able to afford to further your studies. Job shadow. If you're able to job shadow, say in the last 2 years since graduating in 2020, that you, for example, job shadowed at 2 or 3 firms, using that job shadow, you could have networked, for example, with the attorneys that are in that firm, or with other attorneys that you speak out, that you reach, and you may have been, and you may be able to secure articles by networking. I've done networking in the past. I will continue to preach networking. It is the best tool an attorney, prospective attorney, candidate attorney, student, anyone can have. It is by far the most effective way to find employment.
Exactly.
Also have a look on Indeed. Very helpful, very useful. Not Indeed. Outside then. I've forgotten the name now, but there's a social profile that you create for yourself.
LinkedIn.
Pardon? LinkedIn, yes.
LinkedIn.
That's your personal CV. Whenever I meet anyone or deal with anyone in a professional environment, I go and look at their LinkedIn profile. If you do not have a LinkedIn profile, your CV itself is lacking. And I say this with a lot of respect, but it is a good tip to find articles.
In fact, sorry, Ian, if you don't mind me chiming in.
Go for it.
In fact, previously, we've been hesitant to interview somebody who lacked a social media presence. So that just goes to speak to what Ian's speaking about. It's absolutely true. We don't have to have a great social media presence. It's just that if you're kind of not in existence on Facebook, LinkedIn, and the usual culprits, I, as a principal or employer, am wondering, okay, how are you going to market yourself and your skills to prospective clients, your colleagues? Again, the legal field is unfortunately driven by networking. You constantly need to network, you constantly need to sell yourself. In fact, that's 90% of the way we dress.
Also, just to add on to what Bruce has said, when it comes down to having a social media presence, it also allows a potential employer to vet you. I have yet to see anyone who has been to university not post on their social media that they are at university or they're not busy with exams. That immediately allows me as a prospective employer to vet, okay, this person has most likely gone to a university, whether it be UNISA, law school, or Damlin, for example. There's most likely going to be a post. I have yet to meet anyone who has not posted about their graduation.
You'd be surprised.
Be that as it may, it's a manner in which we can vet. It's cheap, it's free, it's easy. Bridget, I hope that assists you in your search for articles, and I truly hope that you find articles soon.
Yeah, something, again, job shadowing, vacation work, definitely great ways to get in.
Yeah, Dimakatso, I see you have a question.
Okay, well,
this is
it depends.
It's going to be, let's start first and foremost. If you're chasing money, do law school, get the 6 months done, secure articles. A lot of firms are looking for people who have done law school because it's a quick in and out. Person comes in, the person goes out, and the law firms are able to then tick the developmental budget requirements. If you're not able to do law school, that's fine. Do your 2-year articles. Get your LinkedIn profile going. Make sure your social media is professional. If you have a social media presence that is you sitting around with friends smoking joints or being completely wasted, you're going to waste your time sending out your CV. Your prospective employers will look for your social media presence. It's a big thing for us.
So, but to answer your question in particular, you said which is it better to serve, 1 or 2 years? It entirely depends on you, your motivations in law, whether or not you want to reach the end of the journey sooner, or what that even looks like. The reason why I'm mentioning all this is because when I was articling and when I got admitted, I felt like the articles were too short, and I did it for 2 years, a little bit more actually. And again, that's just because I realized that the law is like the ocean. It is incredibly vast, and one doesn't realize that yet. With that in mind, I suppose if you want to become an attorney as quick as possible, doing law school and serving articles for a year is potentially the better opportunity. Or doing 2 years, or completing a contract for 2 years, but shortening it to a year by doing law school. Again, there's no right or wrong way. It depends on you, your personality, preferences, and the like. I hope that answers your question. I see we've got another hand up. Seto?
Okay, afternoon, everyone. One question that I want to check before one can decide whether you are going for articles or you go for a pupillage, what would be the advantages and disadvantages of both? Like, because one thing that I know is if you have done your articles for 2 years, or let's just say into a year plus the 6 months of law school, once you are admitted, you'll be able to be an attorney. At a certain time also, you'll be able to convert also to an advocate. But one, if he's an advocate, cannot convert into becoming an attorney. So you become limited. So if you can also further by also assisting with the question of, in terms of practicing the attorney and an advocate, which areas that one can go in as an advocate and the attorney cannot go to, or the advocate or the attorney cannot go into a set as that I said something like that. Basically, my question comes from a point of this one person that I've met. He said, if you have done a pupillage, it will be difficult for one to do the rough claims, but you can only argue them, even also to do conveyancing. So that's what I want to check with. Thanks.
Thanks for the question.
Bruce, may I start this answer?
Yeah, sure.
Okay, so let's start with doing pupillage. You'll become a specialist in litigation. For example, to say that you will have trouble with lodging RAF claims, this is now something for a trust advocate to tackle. It becomes conflated with being an attorney. That being said, if you are an attorney, you can become an advocate. If you're an advocate, you can become an attorney. You can also, so what I would like to suggest, and everyone is different. If you do your articles and you become admitted as an attorney, you automatically have rights of appearance in the district and regional court. After 3 years, you can apply for rights of appearance in the High Court. Alternatively, if you do a course in trial management or litigation management, I've forgotten what the name is, you can then get your rights of appearance much sooner in the High Court. So as an attorney, you will then be able to proceed, operate, and act in any capacity as if you were an advocate, while still being able to be, for example, a notary or a conveyancer. Being an attorney allows you a lot of freedom and a lot of options, if I can put it that way, for you to practice. But again, it is personal preference, and you need to sit down and consider what your goals in life are. Whether you just want to deal with attorneys giving you a brief, or whether you want to deal with a client from day one and walk the matter straight through to the Constitutional Court. It is a personal preference, and it is impossible for us to say which is better. Bruce?
I couldn't agree more with you. Sorry, I think there's feedback. No, like I was saying, I couldn't agree more with you. Going from, well, there's, again, advocates appear in the High Court every day, right? Attorneys are engaging clients, drafting contracts, and strategizing. So it's very hard to compare the two, actually. And yes, the Act tried to do away with the differentiation and try and make the two a little bit more equal. That being said, there's no way to answer. There's no right way or wrong way. I've got friends who became advocates. I decided to become an attorney. And I love being an attorney. I can do all the work an advocate can do. I've got rights experience in the High Court, Supreme Court of Appeal, Constitutional Court, and I'm also a notary. I'm aiming for conveyancing, and then thereafter, I'm thinking about doing becoming a patent attorney. But that is long term. But there is no right or wrong way. I see, Limukatsu, you've still got your hand up?
Yes, thank you so much. So my third question rather is, what information should you have on your CV, especially regarding experience? Because I'm doing my final year LLB, but I've never worked in a law firm or any legal department. However, I have worked in other spaces. So I've been advised to not include what I've been doing because it has nothing to do with law. So I just want your opinion on that in terms of experience. Should I only put the student roles that I've been involved in and not involve any other work because it's not related to anything that has to do with law?
Thank you for the question. I wish there were a right or wrong answer. Unfortunately, there isn't. When I look through CVs, the one thing I look for is to see what sort of experience you have. And I'll be honest with you, somebody who's been employed previously, I tend to favor over somebody who has not been employed previously, because if you've been employed previously, you've experienced the workplace dynamic, you understand the relationship between employee and employee a little bit better. You understand that their expectations, and it's not me being personal with you. It's more me being your boss, so to speak. So I feel that having experience is great. Putting down all your experience in the work field is a great idea. That's my perspective. Other people might have a different perspective. Again, I feel that there is no right or wrong answer. I suppose if you want a definitive answer, you could always approach recruitment agencies and get their input. But typically they say, give us all your information. That's always been my impression from the recruitment centers.
Bruce, I tend to agree with you. And feedback that I actually received in an interview was the demonstration of having previous work experience demonstrates your capacity to fit into specific roles that are created for you or for a candidate with your qualifications, or just for a candidate. Doesn't even have to be qualified. Work experience shows you're able to be dedicated. You have already been exposed to the rigors of de-snowflaking yourself. And I say that, and I've chosen my words. As a student, everything is technicality. This is black and white. Practice is gray area. And having demonstrated previous work history, you've demonstrated to prospective employers that you are actually ready for the role for which you are applying.
Absolutely. Absolutely. And I see SM.
So what can I just ask? So what you're saying is that I can put in any experience that I have, regardless of whatever department I was working in.
Yeah, I would. In fact, I do. But
I
what
just want to also, sorry, Bruce, I want to interrupt you. You must also judge the room. If you want to put in that you've worked at, for example, FNB as an administrative clerk when you're applying for articles, fantastic. Judge the room. Just make sure that, in your own opinion, it is likely relevant.
Okay, I think I differ here. I feel that work experience, in other words, if you were employed to do X, Y, and Z in a work environment, I feel that experience is worth mentioning. I feel experience not in a work environment, in other words, you were not paid to do X, Y, and Z. That is where I have a little bit of a difference of opinion.
Relevance.
Yes. I feel, for instance, volunteering in the SPCA, yes, that's good and all, but you're volunteering, they can't exactly give you a disciplinary hearing for not performing well. It's hard to fire a volunteer. But be that as it may, just bear that in mind that, yes, relevance, charity, you worked, if you list working on the student council as work experience, I would not. I would maybe list that under leadership qualities, not work experience.
Okay, thank you so much.
It's a pleasure.
Bruce,
Okay.
I think we should address SM.
Yes, actually,
a very important comment.
Yeah. I hope you don't mind if I take lead on this.
Go for it.
Thank you. It's not that it's acceptable, it's more the pressures from, I mean, let me give you an idea. That is my stack of files that I have to go through today still. And those are just the files that were drawn physically. All right. That excludes emails, engaging clients, networking, etc., etc., etc. Unfortunately, this practice is rather draining. Well, not this practice, rather this profession is draining. Sometimes the client's going to hate you because you're telling them, listen, you kind of can't kill a person. And they're going to hate you for it, right? Or you tell them, okay, this is a dispute. This dispute that you're having is actually on a particular level, and the services you want us to render are on a different level, and hence they're separate. So I can't help you with your dispute. And clients don't like being told you can't do this because conflict of interest or because it's a poor use of limited resources. Think funds. No point in suing for R5 if the lawyer's going to charge 50,000 Rand. So you're always going to have somebody who's going to be unhappy with you. In fact, it's a bad joke, but it's a bad joke in the profession that you only are truly an attorney once a former client or the opposition has lodged a complaint against you at the LPC. It's just because, unfortunately, law is not a profession where you make friends. In fact, it's one of the most adversarial professions in the world. We literally make a living from arguing in court. Unfortunately, that comes with mental pressures. And also, it often happens that clients will tell you about their legal problem, but they'd also mention their emotional problems, their familial problems and such, and it does weigh on one. So that's what we're actually referring to. The pace, the speed, the heavy workloads, clients that require almost instantaneous feedback or resolutions. And yes, managing expectations of client that goes far, but some clients just do not understand that. So it's not abuse of candidate attorneys, it's more the profession. And also the public does have a particular perception of attorneys and advocates, and that also adds to the burden on our profession, something that I'm and a few of my colleagues are fighting against. Well, I love lawyer jokes, but we all try and be as diligent, as honest and transparent as possible, and it's not quite received as well as we intend. That's what we mean by that. I hope you understand that. Ian, thoughts?
I just want to add, where you've stated that CAs should have more support in a workplace, there are support structures in place in this profession. There are more often than not a lot of groups of advocates and attorneys. They call it burnout groups, where you get together, similar to group therapy. Get together, talk about a couple of things. The probability is of some of these groups will meet at a bar. Then it goes beyond a burnout group and it becomes a safe session. You have to differentiate between your workplace support groups and support groups which are specifically catering to you. Mental health is an issue. It's something that we do address quite often on this forum. And if one has a read around, for example, Dolores Goodenough, advocate, runs a support group for legal practitioners specifically practicing in the law of delict. That is what she does. And
Delict, mind you.
yes.
Now you might now some of you might think, why delict? Well, think about it. What about the poor child that's been disabled because of negligence of the hospital? It does weigh on people.
Yes. For example, if you have a look at cases of cerebral palsy, let's just use the medical negligence. If you look at those cases, you'll often see how badly these mothers are treated, and it weighs on your conscience to such an nth degree that you need a circle of support that is specific and understands trials and tribulations through which you traverse. If you think of an attorney who is pregnant dealing with a medical negligence case, it will most likely make that person sick to their stomach on a daily basis, looking through these hospital records. So there are support groups, there are support places. It's not that we're mentioning that it's acceptable. You are going to be tried and tested in this profession, and it is not for the light of heart. If you are getting into law to make money, I'd suggest going to do a compliance course and working for the banks, where it's an 8 to 5. You have a set list of goals to achieve, and that's it. Being an attorney or an advocate, people come to you with their problems, and you're expected to fix it. That's what makes this so much more difficult. We are people's problem fixers. We listen to, read through, and try and problem solve people's lives. Every file is a life. Bruce showed his desk. 3 files, 3 lives that are affected. To its right, another 3 files that are affected. 3 people's lives that are just sitting on my desk waiting for me to get to them. It cannot be lost. I shot through the roof today because I had a matter where the courier, of all things, couldn't have been bothered to follow our instructions, for which we have already paid them. This has a knock-on effect of a disabled child, and the delay would have been a year because of this blunder that the courier affected. Mental health issues are real, but the support groups are there. It's a reality, we must deal with it. And if you're feeling overwhelmed in this profession, reach out to people. The more you ask, let's use the law of contracts. It's more commercial sense. Find out, okay, so where do the commercial attorneys hang out? Or are there a couple of commercial attorneys that get together once every now and then? There are. If you have a look on the Lawyers Rule Group, where we share one of these links, we have a get together once a year where people from all over South Africa get together at a central position, and we have an afternoon of it. That's part of our support group.
Yeah, and also we mention it to be frank. Right, this forum and this platform, we're not trying to conceal the nasty truths of this profession. We'd rather you be prepared so that you can succeed, you can thrive. It's
a no BS submission.
yeah, yeah. But I hope you understand how we view it, and yeah. That being said,
Are there any more comments from anyone? Or any other questions?
I see one, and I'm going to just reply to it, given the sensitivity of personal information.
SM, you're welcome. I'm glad that we were able to address your comments. It is something serious. Attorneys do sometimes treat mental health as something to be thought of at a later stage. Dimakatso, yes.
Okay, so my last question is, for someone who wants to be a conveyancer, is it possible to write your exam when you write the other 4 board exams, or is it, how does it work? Do you
It's
still
a
have
completely
to...
separate exam for which you must register. You can do it during your articles, and you can be admitted as a notary, conveyancer, and attorney on the same day.
Oh, okay.
Yeah. I've
I
written
wish you the best of luck if you do that. It is grueling. The pass rate last year was 4%.
and it's
I
not a
saw it.
it's not a question of gatekeeping. It's just that it's a highly specialized exam. I've personally written that paper, and I'm not trying to be self-deprecating, but I think, how many times have I written it?
7.
I think that feels about right. But I'm still going to write it again. Unfortunately, I'm a stubborn bugger. But anyway.
I'm also considering it strongly.
Good luck. It's something I can't say on this platform. Yeah. But also bear in mind that there are people, newly admitted conveyancers, who are struggling to get employment. So bear that in mind. Again, it comes back to the value proposition. What am I offering a potential employer that's going to make them want to hire me? Sometimes I look at the job adverts and I see what sort of soft skills and hard skills they're looking for. And that just gives me an indication of where the industry is going. That's just a personal tactic of mine. Use it, don't use it. I would recommend you do use it though.
What I've also seen is firms of attorneys prefer an amount of litigation background before you delve into conveyancing or notary. And the reasoning behind this is simple. You know how to find a problem, fix it, get a solution, research on it. There's a lot of soft skills behind the hard qualifications they want.
Oh, okay. Thank you.
You're welcome. Bruce, I think that should be it. I've got files that are weighing on me, and I am probably not going to sleep tonight.
I thank you guys for all your questions. I wish we could get to it all. Unfortunately, we are pressed for time. We've already actually gone considerably over time. I thank you all. I wish you all well, and we'll see you in the next one. Go well.
Every second week on the same link. Cheers, everyone.
Bye.